Good morning.
Good morning.
Sorry. Sarah Turner. I'm a member of the Memphis Bar. I'm the attorney for the appellant father. I'll be reserving 4 minutes for the rebuttal and allocating 4 minutes to the guardian ad litem.
Okay, let's make sure we've got this correct. Angie, you've got 4 minutes for the guardian, correct? Okay.
Just a brief history of the case. The only signed parenting plan prior to the one that this court, or that the trial court entered in this matter, was entered in 2012 out of Knoxville, when the mother in this case lived in Tennessee and the father in this case lived in Arizona playing in the NFL, exercising a long-distance parenting plan. Father retired from the NFL in January of 2017.
I think you're going to need to pull that microphone a little bit towards you.
Is that better? Okay. Father retired from the NFL in January of 2017. At that time, he resided in and around the Shelby County area. He filed a petition to modify the parenting plan in September of 2018, as mother was insistent that he continue to exercise that long-distance parenting schedule. Mother filed a response to that petition in November, and prior to that, the parties attended mediation in October of 2018. During that time, the parties agreed father would receive additional parenting time every other Thursday after school till Monday at 6 p.m. plus holidays and breaks. The parties began exercising that parenting plan, but it was never entered with the court. Immediately after that, mother began looking for employment outside of Tennessee, but never informed father. The parties then attended an informal settlement conference on May 30th of 2019, where father received 165 days of parenting time per year. This agreement was signed by the parties and began to be implemented by the parties, but again, was not signed by the court. Mother receives an offer from a job in Washington, D.C. That offer letter is dated May 2019. She accepts the offer and signs the acceptance letter July 19th, 2019, and calls a meeting between herself, the stepfather, father, and the stepmother on July 22nd, 2019, wherein she tells the father that she is being considered for a position but has not yet received an offer, but expects to receive it by the end of the week. Father informs her the next day, July 23rd, 2019, that if he were to receive the offer of employment in Washington, D.C., he would oppose the child relocating from Shelby County, where she had lived since April of 2013. Mother files a petition for relocation on August 9th, 2019. She then files a motion for interim relocation on August 12th, alleging an emergency of needing to get to D.C. for her job and the child needing to enroll in school in Virginia. Father files a response and counterpetition in opposition to that relocation on August 15th, 2019, and the court hears argument on that emergency that day. The court denies mother's emergency request, and with that, mother states that she can work remotely from home, and there is no longer an emergency. She will work remotely from home. The parties will continue to exercise the parenting arrangement agreed to in May of 2019, and she will limit her travel to father's parenting time, if at all. The court hears testimony from Mckayla in September of 2019 and October of 2020, and the parties begin their trial in February of 2020, and it continues until November of 2020. The court issues its ruling in November of 2020, and throughout that ruling, mother's status as the child's historical primary residential parent permeates every factor the court considers. In fact, the court says that the paramount consideration that she gave was mother's historical position as the primary residential parent to the child, even though the 2018 revision of the relocation statute says that the paramount consideration should be the child's best interest. The court had a predetermination in this case, which was evident by the court relocating the child to Virginia in August of 2020 without an evidentiary hearing. And you can see that court's predetermination throughout its entire order. Most notably, not a single factor favored the child remaining in Shelby County. Factor D, which is the child's preference, favored neither parent, even though the child clearly expressed a preference in September of 2019 when she stated that she wanted more time with her father, not less. Every time the court asked her, no matter how the court asked her, she wanted more time with her dad, not less. When the court asked her if she wanted to go see her DC, she said yes, but she wants to stay with her father more. Throughout the entire order, the court focuses on mom's historical position as a primary residential parent and discredits any witness who testifies against mother, including the private investigators and the child psychologist, Dr. Christine Malone. It is in the section of Dr. Christine Malone where the court actually states that regardless of the difficult to hear recordings, the effects of mother's statements to the child about father not being involved in her life, and statements to the child by mother that she is tearing apart the family and choosing father over her real family, and the effects those statements had on the child, that mother's historical position as the primary residential parent was the court's paramount consideration. I present to the court that that is not supposed to be the court's primary consideration. In fact, it should be the best interest of the child. In October of 2020, when the child again testified, her testimony did not change, as the court states in its ruling. Instead, she just became more assertive in her position, stating more affirmatively that she wanted to remain with her father. While factor A typically does tend to favor the primary residential parent, it also asks the court to consider the duration and the nature and the quality of that relationship that that primary residential parent holds with the child. Given the testimony and evidence presented in court, we would present to this court that the trial court did not consider the relationship, the nature, or the quality, and instead simply focused on the first 7 to 8 years of Mckayla's life and disregarded everything else and the effect that it had on Mckayla. For those reasons, Your Honor, we would ask that the court find that the mother should not have been allowed to relocate with Mckayla to Virginia.
Thank you.
Thank you.
I think we're going to hear from the guardian ad litem now.
May it please the court, Matthew McCall, the guardian ad litem. There are 3 areas of focus that in the aggregate touch on each relocation factor as enumerated in 36-6-108. The first area of focus relates squarely to mother's plans to relocate this minor child. We began with a timeline in October of 2018 while there's a negotiation between mother and father to give father more parenting time. At trial, we are able to establish that mother had some intention in October of 2018 to relocate from Memphis with the minor child. Fast forward to May 2019, another negotiation occurs. It is reduced to writing. Father's time, again, is increased. At that time, within a day or 2 or 3, the record is not precise, but it is narrowed down to a few days around the end of May. Mother applies for a job in Washington, D.C. Fast forward to the June and July time period, mother accepts a job. She accepts a job before she informs father of her intention to move this child. She lies about it. Then we get into what occurs.
Why do you say she lied about it?
She had signed a contract, or at least
Was she asked about it?
She told father that she had applied for and she was awaiting a decision. She did not have a decision. She expected a decision within a few days. The proof shows she had already signed the acceptance letter.
Had all the details of her new employment been worked out at that time, though?
The acceptance letter is a part of the record. It's very clear. It goes through a timeline. It goes through a salary. And so
I'm sorry, it does include salary?
It does, correct. Now, the Second area of focus.
And what did the trial court say about all that?
The trial court made almost no findings on the timeline and the fact that this meeting occurred and mother had signed a letter of acceptance for this new job. The trial court was essentially silent on the issue.
And what factor does this apply to?
I think that mother's acts or omissions relate to an established pattern of conduct to promote or thwart a relationship with the other parent.
I thought she was giving him more time.
She was giving him more time while she was also negotiating efforts to relocate without telling Dad. She knew she wanted to relocate while she was negotiating this additional time with him. What would have been reasonable and expected is for mother to share that information at the time she is planning to relocate. This court was critical, this panel was critical in Jean versus Harmon of mother's conduct to move to Chattanooga, contractually obligate the child to attend a school without telling father. Mother's conduct here is similar. She negotiated further time or additional time with father, all the while withholding key information.
Wasn't that the case where the mother had, she was married to a doctor? Is that
Correct.
right?
That's-
And it was the doctor who was moving, right?
It was,
The doctor who had accepted the position.
yes, correct. But I believe that there was some also further conduct on the part of mother to go investigate schools while not telling father of this plan that stepfather had accepted a job that stepfather
So it's
was not
not
contracted.
exactly the same, right?
It's different. There is difference. There's a different fact element there, but the spirit of what the court was critical on was withholding information that was critical to that relationship between father and child. Thank you.
What is the
Your Honors.
basis of the mother's obligation in 2018 to tell the father, I'm looking to advance my career? At that time, she had no offer from the Smithsonian.
It is what I believe for the betterment of this child and co-parenting this child, a discussion that I am going to apply for new jobs. Understand that while we negotiate more parenting time, don't be surprised if later I try to relocate. That would have been reasonable co-parenting. Instead, this was, from my perspective, concealing, not for father, but for the betterment of this child. This child finally had more time with father, and yet,
Well, the child could have even more time with the father if the father chose to move himself to Virginia, couldn't he? I mean, because he has a wherewithal to live any place he wants.
he does have that wherewithal. My point is that the child should not be prejudiced by the circumstances earlier in her life because of father's employment. At the moment of that trial, she had both parents with her. And just because father did it before for her, I don't believe that is a pass that, oh, father can continue doing it when the child wants to be in Memphis with father. That's the change. The child now has roots in Memphis and wants to be there.
Thank you.
Thank you.
Now we'll hear from the appellant. Made it pull it down some.
Good morning.
Good morning.
May it please the court, I'm Paula Palazola West from the Memphis Bar. I would like to start from the beginning, from this point about the job offer that mom had. I believe the court did make reference at some point that mom did not have an obligation to tell dad that she is looking for a job. Mom was in a position to withdraw her acceptance if necessary. I also believe that the court included in its order that mom was shocked when dad objected to her relocation because of the fact that he worked for the NFL, and he traveled, and he made the millions, and he did everything that he needed to do. Mom testified that that was her Super Bowl now. It is her chance to go and advance her career. So the court did consider that, and Mom didn't lie since she didn't have that obligation. And this court is correct, Your Honor, with your comment that Mom did give him more time. And it is important to note that there has only been one parenting plan that was reduced to a court order. That was in July 2012. And even though the parties did negotiate and signed or not signed on other parenting plans, they were not reduced into a court order until the final order of the trial court on November 9, 2020.
Let me follow up with the same question that Judge Armstrong asked the guardian, and that is, what obligation does the mother have here, or what obligation does any parent here have about explaining her plans to relocate? Is there an obligation?
I don't believe so, Your Honor. I do not.
I know you said the trial court didn't find one, but is there one?
I do not believe so. No, there isn't one. And the court is correct with Dad testifying that he made millions. I believe he testified he made $7 million one year and 6 or 8 million another year. He testified that he doesn't have to work to get a job ever again, and they can still maintain the same lifestyle that they lived, he and his wife, when he was playing for the NFL. Wife quit her job. He really had no reason why he could not go where the child is. He has the means. He doesn't have any work schedule that confines him in Memphis. Certainly he doesn't have the financial burden of him to travel and see her. And that was a big consideration that the trial court took when granted mother's petition for the relocation. So I would like to go back and just address several undisputed facts in this case, because it is very important to note that Mckayla was born in August 20th, 2008. And then in 2009, that's when Mom took a job in Knoxville and initiated the child support action in juvenile court in Knoxville. And then in 2010, that was the first time that father was drafted to the NFL. And in July 2012, that's when Mom married her current husband, stepdad, Jeremy. And then in 2013, Mom accepted a job in Memphis, and there was testimony, and I believe it was also referenced in the trial court's order, that the move to Memphis was not intended to be permanent. It was only a step to enhance Mom's career. And then in 2015 is when Dad signed a contract with the Oakland Raiders, making $8 million and then another $7 million in 2016, based on his own testimony. In 2015 also is when Dad bought a house in Fayette County, in Piperton, Tennessee. And his fiancée at the time met Kayla for the first time in 2015, based on her testimony. In 2016, father sold his house in Arizona, and his wife was still working and living in Atlanta, Georgia. In April 2017 is when Dad was cut by the Oakland Raiders. But he also testified that he was still negotiating in 2017, that he was still negotiating with the New York Giants. So he was still training, he was still negotiating, thinking that he will continue to pursue his NFL career. Of course, Mom was not privy to those negotiations that Dad had with the New York Giants. In 2017, Mom also started a new job with Shelby Farms Park in Shelby County. That was also an enhancement to her career. In June 2018 is when Dad got married, and in August of 2018, that's when he bought the house in Germantown, Shelby County, and they moved into this home. It was a $1 million home that he bought cash for. And then a month after he moved into Shelby County, that's when he initiated the petition to modify the parenting plan. And in August 6, 2019, about a year later, that's when mom filed her petition to modify and ask permission to relocate. In September 2019, that was when initially the court spoke to the child for the first time, and the child told the court that she would like to spend time with mom and dad. It wasn't a preference as to whether mom or dad, it was, I want to spend time with mom and dad. And then in December 2019, that's when mom had to relocate. We were in the middle of litigation. Mom needed to relocate to maintain her job. And we entered a temporary order that allowed the child to remain in Shelby County in a private school. And there was a provision, specific provision in that order that stated that neither party would be prejudiced by the entry of this temporary order. And then, of course, COVID hit in 2020 and everything was paused. And the only time that the court intervened is when the parties could not agree about the transportation of the child in the midst of COVID. So the child went to see mom in Virginia for spring break, and then COVID, there were no transportation, no flights, and the parties could not agree as to whether the child should come back, how would she come back, where should she stay, how long she should stay. The court got involved and ruled on those issues. The child did tell the court, as stated in the court's ruling, that she would like to stay with mom during that time. And she ended up staying until, I believe, right after Mother's Day. And then she came back, and the court had to intervene again in the summer because the parties could not agree on, again, the summer schedule. After that, that's where we get into this contentious litigation between the parties, starting with August, when the court ruled, knowing that COVID is still going on and we're not going to be able to conclude the trial, that the child needs to go to school somewhere, and neither parent would agree as to where the child would go to school. The court ruled at that point that the mom should make the decision, as she had done throughout all the child's life. And with that being said, Dad filed his Rule 10 with this court. It was granted, and then we continued with the trial. The trial ruled in mom's favor and allowed the relocation. Another motion for stay was filed with this court. It was granted. On behalf of father, I filed a motion with the Supreme Court for review. It reversed this court's ruling on the stay. The father again filed another motion with this court to stay the proceedings. It was denied because it was premature. He had to exhaust his filings with the trial court. Another motion for stay was filed with the trial court, back to this court, back to the trial court, and now we're finally here. So it has been a very, very contentious, lots of filings, very expensive, very time-consuming. At some point, Dad had 3 different motions filed with 3 different level of courts in 1 week. Monday, trial court; Tuesday, Court of Appeals; Wednesday, the Supreme Court. And mom had to defend all those, only to be successful at the end and have her daughter in Virginia in January 2021.
So Mckayla has been there since January of 2021?
Correct, yes. And the parties have been following the parenting schedule that was included in the court order, the trial court's order. So it is undisputed that Dad is retired. He made all these millions. It is also part of the record where Dad complimented mom for doing such a great job raising Kayla, because when Dad was traveling, whether it was for pleasure or professionally, mom was taking care of Mckayla, mom and her husband. They raised her. They have been the primary residential parent of Mckayla. By the time Dad decided that this is it, he's done, he would like to be a dad again, Mckayla was 10 or 11. And now Dad does not want the court to consider any of those factors where mom has been the primary residential parent. I disagree with the appellant's counsel to say that the focus that the court had was only the primary residential parent. Actually, the court made almost 28-page long ruling, went through all the factors, went through all the best interest factors that is in 36.6.108 and 36.6.106 that was specifically requested by Father's Counsel and the guardian, and applied the proof that was presented, her observation of the witnesses, their testimonies, their demeanor, and concluded that it was in the best interest of Mckayla to relocate to be with her mother. It is also undisputed that during the time that Mckayla was living with her mom, up until December 2019, her relationship with dad flourished. She has a wonderful relationship with her dad. It is absolutely undisputed that they have a great relationship. Sadly, father does not give any credit to mom for promoting that relationship that he has with his daughter. Yet, within that short period of time that the child remained in Shelby County with dad, her relationship with her mom deteriorated drastically. The phone calls that were introduced to the court were introduced by the mother to show how bad her relationship had become with her daughter. Dr. Malone did not get involved until the middle of litigation. The child had a different therapist that she was seeing for many years. However, shortly after mom relocated and the child moved to live with dad, all of a sudden there was a need for a new counselor. The child was not comfortable with the counselor that she had. So Dr. Malone got involved. Dr. Malone testified that she based her opinion, her assessment, on facts that were given to her by Mckayla that were never really checked to make sure that she received the correct information. And as it turns out during the trial, that she did not have the right information. She did not verify that information with dad or his wife. She never reached out to mom or her husband. She never did any of that. And the only testimony, the testimony that we heard from Dr. Malone and the mother is that mother reached out to Dr. Malone asking for help because of the way that her relationship was deteriorating with her daughter. And yet Dr. Malone failed to share with her the tools that she gave Mckayla to cope with the difficult conversations that she was having with her mom. She shared them with dad and his wife, but she never shared them with the mom, even though mom reached out to her asking for help, begging her to help to make things better. Also, the year that Mckayla lived with her dad shows us how things are going to look like should Mckayla stay in Shelby County with her dad. Dad testified that he did not invite mom, stepdad, any of stepdad's family to Mckayla's birthday party. He testified, I had nothing to do with it. It was my wife. She and Mckayla did everything. I had nothing to do with it. Yet, no one was invited, and he never communicated to mom that Mckayla was on her flight during fall break, on her way to Virginia to see mom. We were in the middle of Zoom hearing, and I believe it's mentioned in the court ruling that it was so disturbing for mom to find out all of a sudden that Mckayla is on her way to Virginia, and dad failed to list stepdad as someone who's authorized to pick her up from the airport, so we have to abruptly stop the hearing that day so mom can make arrangements and go herself pick up Mckayla from the airport. Dad never communicated with mom about the personal training that he arranged for Mckayla, about the tryouts for volleyball, even though mom was against it because of Mckayla's poor grades. He testified that he encouraged Mckayla to tell her mom, but he also testified that he failed to follow up to make sure that she told her mom, or that he himself told her mom as to what is going on with Mckayla's athletics. He testified that Mckayla did not have any contact with her stepdad's family that were in West Memphis. He testified he doesn't even have the grandfather's phone number. Her grades dropped. She was diagnosed for the first time with depression and adjustment disorder. So there were a lot of concerns that we had while Mckayla was living here. So we asked the court to affirm the court's ruling in regard to the relocation.
Thank you.
Thank you.
Just a couple of quick points. As to Mckayla's testimony, Your Honor can see the transcript. She was clear. She wanted more time with father. That's all she kept repeating. In October of 2020, she was assertive she wanted to live with her father. As to the fact that father suddenly appeared in 2017 and 2018 and wanted to be dad, that is not what the evidence showed. Text messages submitted hundreds of pages that he would travel across the country, coming from California or Arizona, depending on where he was playing, to attend performances, games, parent-teacher conferences, touring schools, sometimes just for a day or two. This man has always been involved in his child's life, and both mother and the court minimized that, didn't even mention it. No credit was given to father for his own relationship with his daughter by mother or by the court, and coincidentally, no credit's given to mother for the deterioration of her relationship with her daughter either. It's everyone else's fault but hers. As to the child's grades, they did not drop. The record is clear, Your Honor. She was an honor roll student before mother left. She remained an honor roll student while in father's care.
Before you use all your time, I'd like to hear about your other two issues as well, the guardian ad litem
Fees.
issue, the fees, and the transportation cost.
Your Honor, I was not able to find any other case where the court awarded all transportation costs to the non-relocating parent. Mother is the one that chose this relocation, and we would present to the court that she needs to share in that burden. She moved for a better paying job, and by her own testimony and by the record, she's earning $175,000 plus and being in Virginia. She needs to help share in that expense. As to the guardian ad litem fees, while the court does reserve the right to reapportion those fees, the mere fact that the guardian ad litem sides with one parent over the other and what the guardian ad litem believes to be in the best interest of the child is not a punitive thing against either parent. It tends to happen in every case. The guardian ad litem takes a position as to the child's best interest. It aligns more with one parent or the other. That is not intended to be punitive, although it was definitely taken as punitive in this case. We would ask the court to reapportion those fees in an appropriate way when the court rules on whether or not relocation should have in fact been permitted. Ultimately, this court has to decide what is in the best interest of this child in light of the amendment to the statute in 2018. If the court takes the position of the trial court, then it's the historical role as mother as the primary residential parent with all of her acts and inactions of little to no consequence. And I present to the court that's not how this court has been evaluating cases since the amendment. It's not how the court evaluated cases prior to the amendment. Thank you, Your Honor.
Thank you. That will conclude the call of the docket for this morning. We'll stand in recess to the call of the docket this afternoon.
All rise.